I'm Stephanie Skaff. I'm a partner in our technology group. My practice is primarily intellectual property litigation and technology disputes. I've been a trial lawyer for, I hate to say this, it ages me, but over 2 decades. Primarily my practice over the last about 3 years is focused on platform disputes and platform companies and the kinds of IP disputes that they get involved in.
Hi, I'm Erik Olson. I'm also a partner at Varela Braun and Martell's Technology Industry Group and Intellectual Property Litigation Group. I've got a broad-based IP practice, but I have also do have experience counseling both platform companies and companies that might what we would call scrapers or API developers concerning the kinds of disputes that might arise between them in the interplay of platform data. So Stephanie, you want to go to the next slide? So just to give you guys a sense of what our background is, as Stephanie and I both said, we have covered, we've counseled companies in a variety of different kinds of actual and potential disputes concerning platform ecosystems. We've represented independent software vendors in API developer disputes. We've been on both sides of those, representing both the platform seeking to restrict access to its data, as well as developers who are trying to use the platform's data to create extensions to it. And we've also been on both sides of scraper disputes, both on the sides of the platforms trying to limit scraping and companies who seek legal protection for scraping. And most notably, we represented ISVs in its litigation against LinkedIn in the district court, and the first appeal to the Ninth Circuit. That case was subsequently appealed to the Supreme Court and then went back down to the Ninth Circuit, where a subsequent opinion has been issued just 2 months ago, and we'll be talking about that a little bit later today. So just to sort of talk about what we're going to be talking about, first, we're just going to give an overview of some of the kinds of players who are in this platform ecosystem space. And then we'll go into the types of claims that that platform companies, the ones who are either creating or aggregating large amounts of data, might bring against scrapers of their websites. Those include Computer Fraud and Abuse Act claims, contract claims, and then other torts and intellectual property claims. Then we'll briefly look at the kinds of claims or counterclaims that scraping entities might bring against platform companies. And then we'll try to wrap this up with some practical tips that hopefully you can take away and apply in your practices. So what kind of companies scrape other companies' website data? It runs the gamut. It's pretty broad. I mean, it's from investment firms to social media companies to e-commerce websites to recruiting businesses. In fact, ISVs was a people analytics company. And what it did is it scraped user information from public LinkedIn profiles, and then it would perform its own analysis of that data and sell that to its clients. And then one of the kinds of companies that actually isn't listed here, but with which we're all familiar that scrape data are search engines, right? So the way that a search engine works is that it has sent out a web crawler across the internet, and these have been around almost as long as the internet, web crawlers. And what they do is they collect and index information from websites across the internet. And when they're indexing information, they have to take some data from the website and store it on their servers, so that when you enter in keyword search terms, they send back to you relevant results. So essentially, it's any company that has any interest in either collecting or analyzing large amounts of data from disparate sources. So I guess we'd like to start with, just to understand who our audience is today, if you can put into the chat whether or not you've actually encountered scraping issues in your work. We'd be interested in knowing that. So just bump it into the chat if you can, and we'll keep going. All right. Well, you can do that as we go along, and we're always interested to know who our audience members are and what kind of issues they're facing. So first, we'll start with the types of claims that platform companies might bring against scrapers. And we'll start first with the Computer Fraud and Abuse Act. So just basics. What is the Computer Fraud and Abuse Act? It is an anti-hacking statute that was enacted in the 1980s, and it's gone through subsequent revisions over the intervening decades. But essentially what it does is it creates criminal liability for a defendant who knowingly accesses a protected computer either without authorization or it exceeds its authorized access within that computer. And it does so with the purposes of either obtaining information from that computer or causing damage to the computer or perpetuating fraud. So again, there are two types of violations of the CFAA. There's one who accesses a protected computer without authorization. They basically have no right to be in that computer doing anything. They're not authorized to do that. And then the second kind is exceeding authorized access. So you as a user may have access to a particular computer, but you are not authorized to access different parts of a computer. Maybe there are certain protected files or a database that you are not allowed access to. Next slide. So last summer, June 2021, the Supreme Court issued a decision in Van Buren versus United States in the criminal context. So this was a criminal prosecution brought under the Computer Fraud and Abuse Act. And the effects there were this. A police officer was paid by someone, a third party, to run another individual's license plate number through a police database and then provide information to this third party for money. Now that was in violation of the department's policy, which prohibited using this database for anything other than for law enforcement purposes. What this police officer used it for was for monetary gain. And so the government brought a charge for under the exceeds authorized access prong of the CFAA. And what was at issue here was, okay, does the department policy, can that create a violation? If the police officer is violating the department policy, is that a violation of the CFAA? Now, importantly, this police officer did have access as part of his job to the database, right? He was allowed to access this database. He was authorized to access the database to run license plates through it. He just couldn't do it for an improper purpose, right? For this monetary gain. So the question again goes to the Supreme Court, and the Supreme Court says, it rejects the government's argument and says, no, what the CFAA is, it's a breaking and entering statute, right? We're talking about technical harm to a computer. We're not talking about violations of policies or misappropriations of information. This isn't it's not an information protection statute. It's a breaking and entering statute. So what we're going to do when we analyze a exceeds authorized access claim under the CFAA and a without authorization claim under the CFAA, we're going to look to whether that the defendant had authorization to access the computer at all, or if he had authorization to access the particular portion of the computer that he accessed. If the answer to either of those questions is yes, then it's not a violation. Now, if he did not have access, if he used someone else's login credentials, or if he hacked in, he got around technical measures to access either a protected computer for which he had no authorization to access, or a portion of that computer that he was not authorized to access, that's a violation. But what we're not going to do is look into the context around the accessing of that computer. We're not going to look at workplace policies. We're not going to look at contracts. Again, this is not a misappropriation statute. We're going to look at, was the gate up for this particular user, or was the gate down? If the gate's down, it's a violation. If the gate's up to this user to get into the computer or into that section of the computer, no violation. And the court goes on to discuss, look, if we agree with the government that whether workplace policies can turn access into a computer into a violation of the CFAA, we're going to criminalize all kinds of innocuous conduct. And they basically said, look, people, probably everybody who's actually watching this presentation right now might be using a work-issued laptop computer. When you get that work laptop, there's probably an employee policy that says you're only supposed to use that laptop for work purposes. But who hasn't checked personal email on their work laptop? Who hasn't checked sports scores on their laptop? And the Supreme Court says we're not going to allow that to become a violation of the CFAA because it might violate workplace policies. What we're going to look to is this gates up or down inquiry. Next slide. So after Van Buren, the Department of Justice, it has updated, actually last month, its charging policies for CFAA claims. And so what it has instructed its prosecutors is that they should not bring a without authorization charge under the CFAA unless the defendant knew that they were not authorized to access the protected computer under any circumstances. And it says that the DOJ has instructed that its prosecutors should not bring an exceeds authorized access charge for violating an access restriction in a contract or a term of service with a web service that's available to the general public. However, if the person who is authorizing use of its website later expressly revokes that authorization through, for example, a cease and desist letter, the DOJ will consider defendants from that point on to not be authorized. And as we'll discuss in just a little bit, this is a little bit in tension with the HiQ decision that the Ninth Circuit has just recently issued. And then finally, the DOJ says that it tells prosecutors that they should not charge good faith research that might violate terms of service. So for example, academics and researchers, there's a public interest in testing websites for security vulnerabilities. And as long as that's being done in good faith and not to actually exploit a vulnerability, that shouldn't be charged. That was what was at issue in a case called Sandvig out of the District of Columbia District Court. Next slide. All right, so that's the criminal side of the Computer Fraud and Abuse Act. There is a private right of action under the CFAA, and it is reserved to those plaintiffs who have suffered damage or loss. And there's a monetary minimum. It's got to be $5,000 of damage or loss. And the statute defines damage as impairment to the integrity or availability of data, a program, a system, or information. And then loss can include basically two large buckets. One, there's costs to respond to an offense, a violation of the CFAA, and to restore the protected computer to its prior condition. And then two, the costs associated with the service interruption. Next slide. And I know we're going through these slides quickly, and you may be interested in getting some of the sites, but as Margaret said, we will post the presentation later so you can go through them more slowly if you want to get to some of the legal sites if we're going to it too quickly. So in Van Buren versus the United States, the Supreme Court actually sort of extending this discussion as to how this is a breaking and entering statute. This is an anti-hacking statute. It really keyed in on these statutory definitions of damage and loss and explained that the focus here is on technological harm. So for example, the corruption of files. And it explains that Van Buren, again, because he had access to this license plate database, and the purpose of that license plate database was to run license plates through it and get information about the owner. It didn't impair the system itself, and it obviously didn't impair the integrity or availability of data in that database. So next slide. So why is this important? Well, if you plan on being a plaintiff and bringing a Computer Fraud and Abuse Act claim, you're going to have to be able to plead and to prove that you have suffered damage or loss, and it's going to have to be of the type that's contemplated by the statute. Now, since the cases that we've cited here have been decided by district courts since the Supreme Court's decision in Van Buren, and most of these are decided on motions to dismiss. So this can be something, if you're a defendant being accused of violating the CFAA, you can prod this in the plaintiff's pleading to determine if they've actually pled $5,000 of the type of damages that are contemplated by the statute. And certainly if you're going to be a plaintiff, you should have your ducks in a row and be able to plead and prove this if it's challenged. So these district court decisions, again, state that the focus is on the connection between the plaintiff's response to an unauthorized access or an exceeds authorized access of a protected computer or portion of that computer. And the focus is on to the damage or impairment of that protected computer. So the loss would not include, for example, unauthorized and improper use of proprietary and company information for the defendant's own benefit. Again, this is not a trade secret misappropriation statute. If I, as an employee of company A, am granted access to a database that contains the company's trade secrets, I go and use my access credentials to download that information and then take it to start another company. That's not a CFAA violation. That might be a trade secret misappropriation claim there. There might be a breach of a non-disclosure agreement claim there. There might be a breach of employee duty of loyalty there, but it's not a violation of the CFAA. Travel costs associated with investigating a violation, or even the cost of investigating what information was downloaded from this improper access, right? So the kind of investigation that the statute is contemplating is someone has entered the computer and caused some kind of service disruption or corrupted files. I have to spend money to either hire an IT expert, or I have to, one of my in-house IT experts has to come and look at this computer and figure out how to make it work the way that it did before this unauthorized access occurred. It's that kind of technical investigation. It's not, oh, someone accessed this information and downloaded files, nothing's broken. That's the costs associated with that aren't going to count towards this loss or damage that's required for a private right of action. However, there are a couple of cases that we cited here at the bottom, which seem to still have a more, I would say, expansive view of what kind of losses can count towards the statutory requirement for a plaintiff to have standing to bring a CFAA claim. So in the Ryanair case, you can see the court found that costs to find, diagnose, and block access to its website constituted a cover loss. And in the Bowen versus Porsche Cars case, the district court concluded that the costs of replacing the damaged computer as a result of the alleged CFAA violation certainly counted as a loss. And the defendant also said that his time that he spent on dealing with this issue, which was worth, I think he claimed $2,000, was also considered a loss under the statute. So next slide, please. All right, so now we're back in the civil context. And this is the CFAA Labs versus LinkedIn decision that was just issued in April of this year. This was just again to recapitulate what the procedural posture of this case is. The case was actually filed in 2017 in the District Court, Northern District of California, and CFAA had sought a preliminary injunction prohibiting LinkedIn from cutting off its access to the publicly accessible pages on LinkedIn. And the trial court granted that preliminary injunction. It went up to the Ninth Circuit. The Ninth Circuit affirmed the preliminary injunction. LinkedIn then appealed that to the Supreme Court. And then the Supreme Court, right after it decided Van Buren, it vacated the Ninth Circuit's decision, which had come out in 2019, and said, okay, redecide this in light of Van Buren. So what this decision in April of this year does is exactly that. It looks at everything again in the view of Van Buren and comes to essentially the same conclusion, which was not really a big surprise after the Van Buren decision. But anyway, this is an application in the civil context. What CFAA did is it used these bots, these web robots that crawl the internet, to collect information about LinkedIn's users. So the information, it's important to note, was information that LinkedIn's users, not LinkedIn itself, but its users created and then posted to their LinkedIn profiles themselves. And this information was accessible on the public version of LinkedIn. So you didn't have to have logged in beyond, you didn't have to be behind a login wall in order to see this data, right? It was basically available to anyone with a web browser. And that's what IQ was scraping, that data. And LinkedIn had sent a cease and desist letter. And the major question for the Ninth Circuit was, look, even in view of the cease and desist letter, is this a violation of the CFAA? And basically what they said was, likely it is not. And the reason we say likely it is not is because, again, this is decided on a preliminary injunction motion, and there's still a live litigation that's still going on in the district court. So this isn't a final decision on the merits of the case, but the Ninth Circuit is saying likely that is not a violation of the CFAA because accessing, basically the concept of without authorization cannot apply to public websites. In other words, that kind of information that's available to anyone with a web browser. And in fact, when LinkedIn sent its cease and desist letter to IQ, that was basically a selective ban of IQ as opposed to a restriction on access that restricted everyone that was accessing LinkedIn's public profiles. So basically what IQ ultimately stands for and likely stands for going forward is that it is going to be very difficult for a platform company to successfully bring a CFAA claim under the without authorization prong of the CFAA if all that the defendant is scraping is information that's available to anybody with a web browser. Next slide. So just to sum up these two decisions, again, under Van Buren, companies can no longer pursue CFAA claims based on an employee or third party accessing a part of a computer for an improper purpose. Rather, they must show that the access to the system or portion of the system was not authorized. IQ versus LinkedIn, companies likely can no longer pursue CFAA claims based on a user scraping data from publicly accessible website. However, we've cited here the Facebook versus Power Ventures case, which is a Ninth Circuit decision from a few years ago. And in that case, the Ninth Circuit had held that Power Ventures had violated the Computer Fraud and Abuse Act after it had received a cease and desist letter from Facebook, because the data that Power Ventures was collecting was behind users' login and password walls. So in other words, this wasn't data that was accessible to anybody with a web browser. They basically had to use these users' credentials to get behind that login to collect data. And the Ninth Circuit, even in the IQ decision, says, look, this is the distinction here. There's publicly available data, and then there's data that's behind some kind of login authorization process. Next slide. So what are some of the other concerns with CFAA claims? Well, one thing that you should be aware of is that terms of use alone cannot be a basis for CFAA liability. And what do I mean by that? I mean that if you run a website and at the very bottom you have a terms of use that says we don't allow any sort of scraping of any data on any portion of the website, that's likely not sufficient to be a basis for a CFAA claim, again, because contractual or policy limitations are not sufficient to create a CFAA claim. You have to have, the question is whether are the gates up to the data? In other words, can I access it? Or are the gates down? I can't access it. That the Facebook versus Power Ventures case actually says this. And again, what was at issue there is there was this login wall you had to get past. Sandvig case had to do with academic researchers who wanted to test websites for security vulnerabilities. It was going to require them to scrape in violation of these various websites' terms of use. So they brought a declaratory judgment action in the district court, and the district court concluded, look, these terms of use, again, cannot be the basis for CFAA liability. So I'm going to find and declare that it can't be. And then finally, Van Buren abrogated. So there had been a split of authority between the circuits before the Van Buren decision. Some circuits found that contracts, for example, like NDAs, could be the basis for a CFAA claim if someone accessed a computer that they had access to, but then obtained information that was in violation of an NDA. That could be the basis for a CFAA claim, and Van Buren essentially abrogated that. There are issues with unconstitutional vagueness too, from the criminal point of view. We've cited the Drew case here, which is out of the Central District of California. Essentially, what that says is, look, terms of use, a lot of times users don't even actually have notice of these terms of use. And we also don't want to delegate to private actors what constitutes criminal behavior. And by the way, terms of use can change all the time. So I might be engaging in certain behavior that's fine today, but if you change your terms of use tomorrow, I'm not going to have notice of that, or I may not have notice of that, and suddenly I'm engaging in criminal behavior, and that's an unlawful delegation of Congress's authority. And then finally, one of the things that the Ninth Circuit discussed in its decision that was issued in April of this year is that there's a concern about granting information monopolies to companies like LinkedIn, particularly for data that they don't own, that their users own and were created by their users. And if we allow them to create those information monopolies, we actually might stifle innovation. There are other competitors. And in fact, IQ was trying to be a competitor of LinkedIn because LinkedIn had its own analytics business that they were trying to run in competition with IQ. And we certainly didn't want that, we didn't want to allow that. Next slide. So here's a little poll just to see if you remembered anything I just discussed in the summary of the case law here. Question, you can put your answer in the chat. If a platform end user gives their password and login to a third party for the purposes of scraping the user's data, does the third party violate the CFAA by scraping the user's data? And I'll hand this over to, here's Ty. No? One vote for no?
So you guys can continue to answer the question. We'll keep going so that we can get through what we have today. But as you can tell from Erik's discussion, CFAA claims have gotten much more difficult after the Van Buren decision and the IQ decision as a basis for limiting or preventing scraping, particularly of public data. So we want to take a look at what other types of claims are available to, and I'm going to use the term platform companies. I know that's not always the best term for everyone, but referring to any type of organization that maintains data on a website that is potentially subject to scraping. So the first one, and kind of the strongest place that many platform companies are going, is contract claims. So the common fact pattern here is that the platform's terms of use prevent scraping and the use of data by third parties for commercial purposes. Most platforms have this provision in their terms of use. And these have been litigated, including in the IQ case. The common response by scrapers, there's really three. The first is the defense that the terms of use are not an enforceable contract. The second is that, some equitable types of defenses like unclean hands or estoppel. And the third is counterclaims directly back against the platform. And we'll talk a little bit more about what types of claims those might be. But let's start with the terms of use provisions. So many of you may be familiar with case law on enforceability of terms of use. The issue has primarily been determined by courts in the context of enforcement of provisions like an arbitration provision or some other type of provision within the terms of use against individual consumers or in the class action context. So there's two kind of key terms of use cases in the consumer context, the Nguyen case in the Ninth Circuit and Meyer in the Second Circuit. And so let's just take a look at the two of those. They kind of set the framework of what the courts look for in cases involving enforcement of terms of use against a consumer. So when the court found that the terms of use were not enforceable, and the court said that in keeping with the court's traditional reluctance to enforce browse-wrapped agreements against individual consumers, they hold that when a website makes its terms of use available on it by a conspicuous hyperlink on every page of the website, but otherwise provides no notice to users nor prompts them to take any affirmative action to demonstrate assent, even the close proximity of the hyperlink to relevant other buttons that the user must click on without more is insufficient to give rise to constructive notice or to create an enforceable contract. So that again, it was a browse wrap. So it wasn't, you didn't have to actually click on the terms of use. And it was also in the context of trying to enforce the terms of use against an individual consumer. In the Meyer case, this involved Uber and their screen, and there were two screens available in this where terms of use were identified, including the payment screen. And there the court found that the terms of use were enforceable against individual consumers. They called out a few things that are worth noting. The first was that the screen where the terms of use were identified by hyperlinks was very uncluttered. So it was, you could see the identification of the terms of use. There was also a clear call to action in a dark font, so the user actually had to do something on that page, which was they were putting in payment information. The hyperlinks to the terms and as well as the privacy policy were very conspicuous. They were clear because the screen was pretty uncluttered, and the user didn't have to scroll to other pages to find the notice of the terms. So in Meyer, they found that those terms of use were enforceable. Cases following that have gone in the district courts have gone some different ways, but the clearest answer in the consumer context is to enforceability is to have two clicks, a click that is specifically accepting the terms of service, and this is the Flywheel Sports case is a good illustration. There, they said the terms of service is distinctive, it stands out to the user, and they also had to click to accept the terms of use. And they said, regardless of whether the user read them, they clicked to accept them, and that was sufficient. And this is what I just put up here, what that looks like. So the terms and conditions, they had to check to agree with it before the user created an account. So Flywheel is probably the best model in terms of being very careful to make your terms of use enforceable, and pretty clear that would pass muster in almost every context. Just in contrast, there's a recent decision out of the Northern District of California in the Roblox case. There, the court found the terms of use were not enforceable against an individual consumer. And I put up the Roblox one here too, and you can see it's also a very cluttered screen. It's also pretty clear where the terms of use are. They're in a different color, the hyperlink. There is action that the user has to take on the page, and they do have to click the sign up, but they're not actually doing the double click of clicking the terms and agreeing to the terms of use. And the Northern District in this very recent case found that was not enforceable against an individual consumer. So what we're talking about in this context is enforcement of terms of use against usually a commercial web scraper. So a web scraper that is scraping data for use for commercial purpose. It's usually a business. And in those cases, the standard really is has been there's fewer of those cases, so we don't have a really good view of how this is going to play out. But in general, courts have been much more willing to enforce terms of use against commercial parties. So I've listed 2 cases here. Both of these were very early stage cases. So International Council of Shopping Centers, in that case, the party was, they were scraping membership data organization from, and using that to basically solicit customers. And that was a violation of the terms of use. And in the Southwest Airlines case versus Round Pipe, and there's been a couple of different Southwest Airlines cases, both all in Texas. There's another one called Southwest versus Kiwi. Both of those cases were also resolved very early on. In the Round Pipe case, after on a motion to dismiss, that primarily dealt with a TCPA issue, which is Texas's anti-SLAPP statute, and the court rejected that. But in the course of that decision, the court also rejected a 12b6 challenge to the contract claim. Round Pipe was basically was a commercial entity that was scraping a Southwest Airlines site for fare information. What they realized was Southwest Air, if a consumer bought a Southwest ticket, they could change that ticket without a cost. But so if the cost of the flight went down, they could actually save some money. But they would have to continually monitor the site to know that the fare had dropped. And so Round Pipe was like, oh, we're going to provide this commercial service that does that for them, and we'll just continually scrape the fare information from the site and make a little money off of giving the consumers that price differential availability. So the court, again, in a motion to dismiss, said the terms of use contract claim was sufficient on at the pleading stage, that on a 12b6 motion. There's also a case, the Ryanair case that was decided under in Europe, and that case also suggests that terms of use in a commercial context are enforceable against a company that's trying to scrape data. So the general sense is that courts are going to be more willing to enforce terms of use in the commercial context. But again, even if the terms of use are generally enforceable, the CFAA case presents a cautionary flag about when those terms of use will be, courts will enforce the terms of use when the scraping activity was public data that's scraped, and where there are competing First Amendment concerns or other public policy considerations. So CFAA was primarily involved the CFAA, which of course has as Erik said, has a criminal portion to it and a civil portion to it. So in interpreting the scope of the CFAA, the courts were very cognizant of the determination on what would amount to a CFAA violation must take into account the fact that it could be a criminal, this could attach criminal liability as well as civil liability. That same consideration is not present when you're talking about a contract claim or any other type of straight civil claim. So these claims are likely to get less scrutiny in terms of enforcement. But that does not mean that these considerations are not going to be raised, and in fact are being raised by scrapers. Most of these cases have not proceeded far enough to really generally they resolve fairly early by stipulation or otherwise. But scrapers are raising concerns that, the data that they're scraping doesn't actually belong to the third party that's trying to enforce their terms of use and contract. And so that there's public policy considerations which should make the contract unenforceable. And same with First Amendment concerns. Those two kind of overlap in the sense of, again, the protection of data that does not belong to the company itself. So there's some distinction in terms of what the scraping company, what type of data they're actually getting. And in some situations, like in the Southwest cases, the scrapers were taking Southwest information, right? It belonged to the company. It was their fair information, and they also had trademark claims in those cases where they were pulling their trademark logos off as well. So that the public versus company data is a distinction. I also wanted to just briefly mention the Clearview cases. So these the Clearview is a company, and Clearview AI, they're a company that does facial recognition AI, and Clearview had been scraping facial identification information across many different areas of the web. So they received a number of cease and desist letters from Twitter, from I believe Facebook, and others, to cease and desist scraping the public, scraping the facial recognition information, personal information off of their sites. Apple actually suspended their developer account, so they couldn't continue scraping from that site. And then the ACLU actually sued them. And the ACLU suit proceeded under a statute in Illinois called the Biometric Information Privacy Act, BIPA. And in that case, Clearview raised a First Amendment defense that this was, public information, and that they should be allowed to access it under the First Amendment, and that the BIPA's prevention of that was unconstitutional. The court rejected that defense. First of all, they noted that Clearview was scraping this data for a commercial purpose. What Clearview did was it would scrape all this facial recognition data, and then it would sell that data to governments and other entities, particularly law enforcement, who could use it to help identify suspects in alleged crimes. So they were using it for a commercial purpose. And the court said that that because of that, this was going to get intermediate scrutiny, and that they found that the state of Illinois had a strong reason for the enactment of the BIPA and the protection of facial recognition data for consumers. So Clearview was not a terms of use case. It was not a contract case, but it did raise these First Amendment concerns, and those and the data ownership. Whose data is this? If it's my face, does that belong to me, or does it belong to the website where it's hosted, or is it available to anyone if it's public? So these are really interesting issues. They're still circulating through the courts. The Clearview case was settled after with a stipulation after the initial decision on the BIPA finding it constitutional. So as you can tell, the terms of use issue in the scraping context is continuing to roll its way through the courts, but that still continues to be kind of the strongest place for companies to stand if they're looking to prevent web scraping, particularly of data that the company itself owns. But a lot of times the contract claims are grouped with other claims, CFAA, if there is actually the kind of loss or damage that Erik mentioned, and there was some kind of technical gate that has been breached by the scraper, but also intellectual property claims, including trade secret claims. Those claims really go more to the information that was taken rather than to the method by which the scraper used the information. And obviously the trade secret claims are not going to be involving these cases where scraper is taking publicly available data. There are copyright claims if scraping takes data that is substantially similar to the format and in the tangible medium of the website, or if it takes copyrighted information. And then there's also trademark claims, as in Southwest case, sometimes companies, particularly data aggregating companies. So that could be a travel aggregator, it could be a coupon company or a price aggregator. Many times they'll scrape information that includes the trademark name or logo of the underlying site owner. And so there are trademark claims that come up there too. Other types of claims that we see are privacy related claims, particularly these arise in cases where it's personally identifiable information that's taken. Oftentimes there's a question of standing there. So those claims may be brought not by the platform itself, but by the consumers or as class actions. There are interference claims or interference with other contracts that the platform may have. Trespass of chattel has been one that has been relatively successful in courts. That really requires that there has been some kind of incursion, more like a CFAA type of violation, incursion onto the system. And then fraud, again, sometimes if a web scraper is using misrepresentations in the way that it presents the data or presents itself to the platform, that can give rise to other claims like fraud. Okay, so let's see. In our last few minutes, we're going to quickly go and talk about some of the potential claims, and these usually come up as counterclaims that are asserted against platforms. So the big ones here are breach of contract or promissory estoppel type claims, interference claims, sometimes intellectual property claims or other tort claims, and the other biggie is antitrust claims. The common fact pattern that's generally alleged by scrapers or third-party API developers or ISVs or partners or former partners is that the platform made some kind of public statements promoting an open ecosystem. And then the platform knew that the developer built its business relying on continued access. So most of these kind of counterclaims come up, or claims come up, in cases where there had been some type of relationship between the third party and the platform. Maybe the third party had been developed an ancillary service. It had existed side by side, and then maybe was terminated at some point because, and a lot of times the allegation is because the platform wanted to compete against us and develop that business itself. The common fact pattern that's alleged in the antitrust or unfair competition type claims is that the platform, again, kind of in a similar theme, launched or is planning to launch a service that is competing with the terminated party, or that they actually acquired one of the terminating party's competitors, so are now operating a competing service or business. I'm not going to go too much into the antitrust unfair competition because we have a whole nother program coming up in June where we're going to talk in detail about antitrust and unfair competition, not only what has happened, but also some of the new regulations that are coming down the pike that are going to, that are changing that, that area. So stay tuned for that. But in the meantime, I just want to let you know that these are some of the claims that scrapers sometimes, or third parties, sometimes bring in connection with termination. Interference claims are another big one, and the common fact pattern there is that the platform knew about the developer's customers or contracts, and that they then sent a cease and desist letter or somehow denied access to the platform, either through contract term changes, deprecation of the API, or shut off of access in some other way. And then the developer was, because of that, unable to perform on its own contracts or to continue in its business. And so the knowledge of the customers or contracts is key to being able to allege this case if you're a third party. Okay, so to just kind of wrap it up, we want to go through some quick tips that are practical on both sides of the V here. So if you're a platform and you are terminating access or having difficulty with a web scraper, here's some of the things that you should be thinking about. The first is, of course, making sure your terms of use are up to date and that they actually do prohibit unauthorized use of data. Suggestion that you have terms of use that require a click, but again, that's those cases have occurred in the consumer context. So in a commercial context, at least notice on the pages that are being scraped is really what you want to make sure you're providing. The second is if you are going to terminate or restrict access, to try to do it on a party neutral basis. So don't target specific parties or specific kinds of services. That helps with allegations that this was a kind of targeted termination because of wanting to compete or something like that. You might want to review your press statements, contracts, and correspondence with third parties to identify if there are potential reliance or promissory estoppel issues that might come up. One of the big things that we recommend is to consider some grace period when you do a cease and desist. That helps reduce the risk that you're going to get hit with a TRO or a PI motion right out of the gate. Gives you some time to resolve the issue and hopefully never have to litigate. And finally, termination is strongest if the data is not publicly accessible and is owned by you and not by your users. So that's something to consider in the circumstances when you're evaluating the strength of your claims. So if you're a third party and you are scraping data, what should you be thinking about? Well, the first thing is make sure you're reviewing the website's terms of use and the robot.txt file carefully before you start web scraping. So those are going to give you the ground rules for what the service believes is appropriate and not appropriate. So you want to make sure that you are aware of that. You should also consider the technical measures the website is taking to restrict web scraping, and that can take a variety of forms, but this is going to be important in CFAA analysis and whether or not you're actually getting yourself into a situation that could actually not only result in civil liability, but criminal liability under the CFAA. You want to, again, avoid any kind of adverse impact on the website's physical operations. Or any harm to the computer system itself. Those could give rise to CFAA claims as well as trespass to chattels types claims in the civil context, common law context. Always avoid any web scraping activity that could be perceived as intentionally misleading. Obviously, that would be fraud or consist of fraud, and you want to make sure that you stay far away from that. And avoid collecting personally identifiable information. That one is that one really has to do more with the consumers themselves, and if those people are your clients and you have permission, but you just need to really evaluate that issue carefully and see what type of information you're obtaining and whether that information is already publicly available, and also whether or not it's information that would violate if you used it in the way you're intending, would violate any of the privacy statutes. And that is a big area that we don't have time to go fully into today, but it's something you should keep in mind. You want to consider whether it's protected by copyright. That's another place where claims can arise. And the last thing is really, think about the model of your business and just be prepared to stop if you're asked to stop through a cease and desist letter. A lot of web scraping is really not objectionable in the sense that there are academics doing web scraping. There's lots of different organizations that do web scraping. It's not even companies themselves who might otherwise be opposed to web scraping, do some web scraping for data analytics purposes. So again, you just want to look at this through the view of kind of what's the purpose of it. If it's solely a commercial purpose and it's competing, you need to or potentially competing with by using data that particularly data that could be perceived as belonging to the platform itself rather than individual consumers. You're treading on more risky ground there. If you're thinking about asserting counterclaims and you get into these kinds of negotiations over access or termination, you want to make clear that you are relying on continued access. You want to identify any public statements regarding continued access or open ecosystems, and you want to identify potential anti-competitive motivations for termination. And you do want to consider a TRO or a PI. That's a quick a way to get in front of these claims. And if there are true anti-competitive reasons, or if the termination has been one that came after a business relationship that has gone on for some period, then you might be in a position where you have legitimate and claims to bring, but if you don't act quickly, your business could be, might not survive. So that's something to consider. You do need evidence of irreparable harm if you are pursuing a preliminary injunction, and usually the types of things that we're talking about where you are relying on continued access, and so that there's a destruction of your business, that usually is sufficient. So that's it. I realized I was talking kind of quickly and we went over just a little bit, and covered a lot today, but we have our contact information up here, and Erik and I know are both happy to take further questions and answer further questions as we go. If you have any, you just feel free to reach out to us. And that concludes the presentation for today.